Once upon a time, not so long ago, there was a bachelor working in real estate and he was new to the grind. A wannabe famous girl who never works a job, who knows how to write dating contracts. She says we gotta hold on to what we've got, even if it one-sided, it will mean a lot. We gotta hold these fake babies, and that's a lot for love. Please give me a shot. Oh, we're halfway there. Oh, hold me like I'm pregnant. Take your hand and place it right there. Hold me like I'm pregnant. Oh, on my moon bump belly. The bachelor starts running away, but there are pea sticks thrown in his face, and the girl says all I did was get pregnant by the bachelor. With two PJs gave away. Oh, we're halfway there. Oh, hold me like I'm pregnant. Take your hand and place it right there. Hold me like I'm pregnant. Oh, on my moon bump belly. We gotta hold on to these fake babies, and they are coming whether you're ready or not. This is all I've got. Oh, we're halfway there. Oh, hold me like I'm pregnant. Take your hand and place it right there. Hold me like I'm pregnant. On my moon bump belly.
Okay, that should fix it. Right? Still not fixed? Okay, good. I guess I had pressed the button on my mic. So, sorry I'm late. My daughter needed me to do something real quick for her, and then I had to let the doggo out. Came home later than I expected, but we are all here now. So, Gingras we knew from, I guess, yesterday that he was going to go up to the Arizona Supreme Court. We also know that David Gingras wants to make a case name for himself and create new law that people will cite to. And this is, a case of, as they're calling it, first impressions. And my only thing is with this is that he would be fine doing what he's doing and fighting this fight if he was like getting arrested and like losing his freedom and things like that. If it was a criminal prosecution, he would be all good. But I don't think that it works in this context. Now, I will be glad to hear what the Supreme Court does say about this. And he may create some case law, but it might not be the case law he wants. So let's pull this document up. There are tons and tons of stuff. His motion is 40 pages. And then there are volumes and volumes of other stuff. And there's only one thing. I think there's only one other thing that I want to look at that's in one of the volumes that I've at least found thus far that I want to take a look at outside of his appellate arguments. It's going to be a lot of the same crap. But like I said, I am interested to see what they say about this. I don't think he's correct, and I don't think he's going to win this at the end of the day. But, you know, courts will surprise you. So, well, this is not what I wanted. Let me do something real quick. Okay. Now let me pull this up. Afraid to move anything else. Yeah, because those are the larger ones. Okay. And of course, welcome to everybody that is here. Don't forget to hit that like button. Subscribe if you're not already. If you think you're subscribed, double check. All right. So, to the Arizona Supreme Court. And we know that if he doesn't win here, he's going to take it up to the United States Supreme Court, possibly. Gingras versus the State Bar of Arizona. And this is by Mark Randazza. Lovely table of contents, table of authorities, lots of tables of authorities. I'm citing to all these cases because they stand for what I want to say. Introduction. This case presents an important constitutional question. May Arizona discipline an attorney for truthful public criticism of a judge on a theory that the First Amendment does not protect lawyers in the same manner as other citizens? First of all, where's the truth? I mean, the first line is a lie. I don't know what truthful public criticism he made. I see that he had a lot of things to say based on nothing. The presiding disciplinary judge answered that question, yes. Accepting the state bar's argument, the court held the protections of the United States and the Arizona Constitution yield to the Arizona rules of professional conduct when the speaker is a licensed attorney. Well, you took an oath and you said you were going to behave in a certain way. You didn't have to take that oath. That conclusion cannot be reconciled with settled constitutional law. For more than 50 years, the United States Supreme Court has consistently held lawyers do not surrender their First Amendment rights upon admission to the bar, subject only to a handful of narrowly defined exceptions that have no application here. The bar's position asks this court to recognize a new class of citizens who enjoy less First Amendment protection solely because they are licensed to practice law. No decision of the United States Supreme Court nor the Arizona Supreme Court supports such a proposition. The decision below threatens not merely petitioners' constitutional rights, but the free speech rights of every attorney in Arizona. This court should not permit that result. As Judge Gorsuch recently observed, lower court judges may sometimes disagree with this court's decisions, but they are never free to defy them. Okay, we're just going to end there. All right. Jurisdiction. The court has jurisdiction to hear this appellate special action pursuant to Article 6 of the Arizona Constitution and Rule 4 of the Arizona Rules of Procedure for Special Action. Special action jurisdiction is especially appropriate here because, 1, the challenged orders are interlocutory but conclusively resolve important issues of constitutional law, which this court has held warrant enhanced appellate review. Enhanced appellate review in cases raising First Amendment issues provides assurance that the foregoing determinations will be made in a manner so as not to constitute a forbidden intrusion of the field of free expression. The presiding judge expressly recognized this case presents issues of first impression, further confirming that special action review is appropriate. This case raises legal issue of statewide importance. The resolution of the legal issues involved will materially advance the efficiency management of this case. Petitioner has no equally plain, speedy, or adequate remedy by appeal because the loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. Statement of issues. They don't know what the truth is. That's why I hate that Randazza is on this, because I usually do agree with a lot of what Randazza says. But usually I see him on like criminal stuff. I don't see him on this type of case. Statement of issues. Must attorneys surrender their First Amendment and Arizona free speech rights by becoming members of the Arizona bar? If he is just acting as a normal person, no. But he was acting as a lawyer. He was doing it in his lawyer capacity. Do Arizona attorneys retain the same First Amendment and Arizona Constitution protections as other citizens? And if so, did the state bar establish that petitioner speech falls within the recognized exception permitting discipline? Did the presiding judge err by granting judgment on the pleadings when the material facts were disputed and by applying an erroneous legal conclusion that the First Amendment and Arizona constitutional protections for speech do not apply to lawyers? I don't think that that's what he's saying. If he was out on the sidewalk just as an average person, not anybody's attorney or anything like that. And he wanted to go and say the police suck, but he's not doing it as an attorney. He's just doing it as himself. No, I don't think can be he can't be disciplined for that. But this was all while he was a lawyer and of a certain case. So it's not saying that just because you're a lawyer, you don't have First Amendment protections. That's what they're trying to turn it into, but that's not what this is. And he put some of this shit in a pleading, which was in court. Even if they took his out of court statements and said, no, those don't apply here, he can do whatever he wants. But that filing about the judge and the look at me daddy comment, I feel like that's an in-court. That's an in-court statement. It was in a filing. Does Arizona's newly expanded anti-Slapp law, ARS 12751, apply in attorney discipline proceedings? And if so, does it unduly hamper this court's authority to regulate the practice of law in Arizona and therefore violate separation of power principles? Why is there so much space in all of this? Statement of facts. This attorney discipline proceeding arises from respondent State Bar of Arizona's attempt to discipline petitioner David Gingras for, among other things, his truthful public criticisms of a Superior Court judge. No, that was not a truthful public criticism. See, I can't take you seriously when you say that. Yes, he wants his landmark ruling. Get out of here with this truthful public criticism. That's no, it's not truthful. It's not based on any facts. His petitioning activities and other speech related to matters of substantial public concern. Mr. Gingras has been a licensed to practice law in Arizona since 2004. The disciplinary charges, which they say see State Bar's amended complaint, petition appendix exhibit 1, stem from petitioner's representation of a party in Owens V Echard, a highly publicized Maricopa County family court proceeding, because the case involved a former TV star of The Bachelor and extraordinary allegations of fabricated pregnancy. It attracted widespread public attention, excessive social media coverage, and live-streamed court proceedings. Following the trial, the Superior Court judge ruled against Ms. Owens, awarded approximately $150,000 in attorney's fees against her, and referred the matter for criminal investigation. Mr. Gingras was not accused of participating in or having knowledge of any alleged criminal conduct. Bullshit. You knew she was a liar. During and after the litigation, Mr. Gingras engaged in several forms of speech and petitioning activity that later became the subject of disciplinary charges. This included criticism of a trial judge, communications with law enforcement, and private communications unrelated to the practice of law. No. Everything he is charged with has to do with practicing law. Law firm website blog. Filings of court documents with medical records in them. Statements about a judge. That multiple courts told you were ridiculous. The state bar alleges these statements violated the rules of professional conduct. Mr. Gingras maintains his statements were either factually true, constitutionally protected opinion, or otherwise protected by the First Amendment, the Arizona Constitution, and Arizona's anti-Slapp statute. See his answer. A principal focus of the disciplinary proceeding concerns petitioner's public criticism of the trial judge in Owens. That criticism arose after petitioner discovered information suggesting that the trial court relied upon facts never introduced into evidence and considered material originating outside the trial record. Based on the trial transcript and other evidence, petitioner filed a verified notice of change of judge, supported by an affidavit, setting forth the factual basis for his concerns. The request was denied, but the allegations were not adjudicated to be false. Well, the thing is, if you look at other evidence, and I bet one of your pages, I may have to go through and find the page in your filing, but your law firm website is a clickable link in a footnote. So you made your website a link, or Woodnick or somebody did. Put it in a filing, and she can review that. And if she saw comments that gave her some of that information, she could have actually gotten it legally. I have a video breaking down all of that. That I've done already. After petitioner filed his answer asserting that the challenged speech was protected by the United States and Arizona Constitution, the state bar moved for partial judgment on the pleadings. The bar acknowledged factual disputes existed, but argued they were legally irrelevant because constitutional free speech protections are not a valid defense in an attorney disciplinary proceeding. Petitioner filed a lengthy brief opposing the motion. The presiding disciplinary judge, the PDJ, granted the bar's motion in part, holding petitioner's constitutional defenses failed as a matter of law. Which all these things we've gone over already. Petitioner later moved to dismiss under ARS 12751. The court denied that motion, concluding constitutional protections for speech did not bar attorney discipline, and further concluded Arizona anti-Slapp statute could not be applied in disciplinary proceedings because it would unduly interfere with this court's authority to regulate the practice of law. The court expressly recognized that its interpretation of Arizona's anti-Slapp statute presented an issue of first impression that could warrant special action review. Which is why the judge was like, yep, I will halt all scheduling until we hear back from the Supreme Court. And I think the judge is interested to hear what they have to say as well. Oh, Colorado Canadian, you've been watching Jack oh so much. Yeah, but Randazza thinks that everything is free speech and that nobody should ever. I agree, people shouldn't go to jail over their words, but I mean, unless you're like threatening somebody. And then if you're just flat out lying about it. I just think they are trying to make this into something that it's not. they're trying to say that lawyers, no matter what they're doing, like like when Gingras is moving, if he tells like he's not being a lawyer at this time. He's just a guy that is moving locations. And so if he like cusses out the movers, or he writes review, a bad review on like the movers, they're not going to be like, well, you're a lawyer and you can't say that. He would be able to say that unless he was lying. I think he did commit witness intimidation, in my opinion, Berkeley. Yeah, I think he can have consequences for his words. And apparently you're not supposed to have any consequences. And I'm like, that's not how this works at all. Petitioner now seeks special action relief because the rulings below hold as a matter of law that the First Amendment Arizona Constitution do not protect the speech at issue, and because those rulings present reoccurring constitutional questions of statewide importance. I agree. This needs to be decided on. Hopefully it's telling Gingras that he's wrong and dumb, but that's just me. Argument. Special action review is particularly appropriate in free speech cases like this one. This court has repeatedly recognizes interlocutory review is especially appropriate where a case presents substantial First Amendment issues in Citizen Publishing Co. versus Miller. This court acknowledged it's a general policy of declining special action jurisdiction to review orders denying motions to dismiss. Nevertheless, it explained that there is good reason to depart from this general rule when a suit raises serious First Amendment concerns. I don't really care about these other like sightings necessarily. I'm not saying that they're not important in other ways. My concern is the cases that they cite that have to do with a disciplinary bar and a lawyer. I don't care about a criminal court citation. I don't care necessarily about a civil court citation. Those are different, in my opinion. Because he's not losing any monetary, like he's not going to be made. Well, I guess maybe, I don't know if they could sanction monetary damages. I don't know if they can do that, but I think all they do is suspend your license or take it away or whatever. I don't know what else they can do. In cases in which an appellate court can determine from the pleadings a case dispositive First Amendment defense, special action review of the trial court's refusal to grant motion to dismiss may be appropriate. Such a procedure relieves the parties and court of a prolonged, costly, and inevitably futile trial and protects First Amendment rights. This case presents an even stronger basis for interlocutory review. The presiding disciplinary judge has already resolved the controlling constitutional issue as a matter of law, holding petitioner's First Amendment and Arizona constitutional defenses fail, even if his speech was entirely truthful. Based on that holding, the parties will be required to litigate the remainder of this disciplinary proceeding under the legal standard petitioner contends is fundamentally incorrect and inconsistent with controlling state and federal constitutional precedent. Did they say that even if he was making truthful statements, it doesn't matter? I don't remember that being in the order. Let me see here. What is this? Let's see. I can't look at that one. Damn it. Okay. Based on that, holding that the parties will be required to litigate the remainder of the disciplinary proceeding under legal standard contends is fundamentally incorrect and inconsistent with controlling state and federal constitutional precedent. Immediate review is therefore necessary. If the ruling below is erroneous, delaying review will require the parties and the disciplinary judge to expend substantial time and resources litigating, aggravating, mitigating, and other issues that may ultimately prove unnecessary. More importantly, the PDJ's ruling forecloses factual development on issues directly bearing on petitioners' constitutional defenses, including the truth of the challenge statements and the factual basis supporting them. He doesn't have a factual basis supporting shit. Hold on, I have to turn on my fan. Be right back. Okay. Yes, you unzip the moon bump and out falls the spaghetti, the burritos, all of it. I could go for some good spaghetti. That sounds good. Yep. Exactly, Bruce. The bar is not sending DSG to jail. We would be having a completely different conversation. I would be on Gingras' side if they were trying to send him to jail over this. I just don't think what he said is correct about what that. I'm gonna have to go back and reread that ruling. The PDJ erred by granting judgment on the pleadings. The presiding disciplinary judge granted the bar's motion for judgment on the pleadings based upon a single flawed legal premise that petitioners' First Amendment and Arizona constitutional defenses failed as a matter of law because attorneys do not enjoy the same constitutional protection for speech as other citizens, not while they're acting as an attorney. Just like if you're wearing your Chick-fil-A uniform, you cannot do things in that uniform, say certain things, do certain things while you're representing yourself as a Chick-fil-A employee. If you are not in your uniform and you're doing things, then have at it. It might get back to Chick-fil-A and they might say, we don't really want you here. Do I have that filing? I wonder if I have that filing. Hello, Wallace. If anybody wants to be really nice and send me the judge's ruling, because it would take me forever to get to it. Let me see here. Maybe this is it. That was back in March. Let's see. I don't think that's it. If somebody wants to send me the ruling that the judge made to my email or on Twitter, that would be great. I want the latest one that she ruled on. It might be that March one, but I'm not seeing what he's saying. Moreover, even apart from the constitutional error, judgment on the pleadings was independently improper because petitioner answer denied essentially factual allegations and asserted legally cognizable defenses. Before my time is not a cognizable defense. Under settled Rule 12C principles, those disputed factual issues require denial of the bar's motion. Yeah, but he agreed to doing those certain things. He tried to put justifications in there, but that doesn't necessarily mean that that was a legal way to do it. The bar was not entitled to judgment on the pleadings. A motion for judgment on the pleadings tests only the legal sufficiency of the pleadings, not the evidence. The court must accept the non-moving party's well-pleaded factual allegations as true, construe all reasonable inferences in the party's favor, and deny the motion whenever material factual disputes exist, or the answer asserts a legally sufficient defense. Those standards were not satisfied here. Petitioners admitted making certain statements concerning the trial judge in Owens, but expressly denied that any statements were false or made with reckless disregard for the truth. They were made with reckless disregard for the truth. That is for sure. Footnote 1. Reckless disregard is shown if the attorney had no reasonable factual basis for making the statements, considering their nature and the context in which they were made. He didn't have factual basis, a reasonable factual basis. He had speculation. And he even admits things. He will even say, maybe she did come by it honestly and knew these things, but I'm going to assume the worst because I assume the worst of everybody. The answer further alleged that the challenged statements were either factually true, constitutionally protected opinion, or made with a good faith factual basis to believe that they were true. No, he did not make a good faith factual basis in his beliefs. Formed after a reasonable investigation. No, he said that some talking people made statements, and those talking people he thinks are not credible, but he is deeming them credible in this situation. So are we credible or are we not credible? Which one? Can't have it both ways. Those allegations alone created disputes, issue of material fact, and asserted facially valid constitutional defenses. Accepting those allegations as true, as Rule 12C required, the bar was not entitled to judgment as a matter of law. A plaintiff's motion for judgment on the pleadings should be denied where issues of fact are properly raised by the answer. The PDJ nevertheless granted the motion because she concluded those factual disputes were legally irrelevant because, in short, truth is not a defense. No, that is not what she said. Right. Correct, Bruce. Yes, Jupiter, for sure. Assumes the worst of everybody except for Elo and her family. The judge did not say that truth is not a defense. This is disingenuous. According to the PDJ, even entirely truthful criticism of a judge may be disciplined because attorneys do not possess the same constitutional protections for speech as other citizens. That legal conclusion is incorrect. Are you kidding me? Oh, yeah, for sure. I don't see Hey Rob in here. If anybody sees Hey Rob, let me know. The PDJ's constitutional analysis conflicts with controlling the Supreme Court precedent. Oh, thank you, Treat Fairy. That's very kind. Oh, look at the puppers. I love it. Well, that's what he wants to do, Bruce, is that's why he wants to cross-examine and do a deposition on Mata so that he can find out whether it's true or not. Yeah, he was suborning perjury, and he knew it. Because what I've learned a lot of different things that I didn't necessarily, if I did catch them then, it slipped my mind. But when Bacon Bears finally got to the June 10th hearing, it was interesting because there is a part in there where he asks about, you know what, that's something we can pull up too. It's when he's asking her about the Planned Parenthoods that he went to. And it's very, very interesting. Lord, I would have to find it in the transcript. If there is a transcript. Is there a transcript? Oh, okay. That's him arguing, doing a little spin. I may have to look at that later. But he asks her a question about what Planned Parenthoods she went to. And the way it was worded made it to where but it was like it made it to into her not lying. Where is my little... There we go. He says, did you have a sonogram in California? He didn't ask her about a specific county or anything. He said, did you have a sonogram in California? Which makes me think he made sure not to specify a county. I mean, she didn't have one in California, so it's still a lie. But if he was like, okay, there's no records for Orange or San Bernardino. So she's like, yeah, but you didn't do Los Angeles. But he said in California, so that technically she wasn't lying. Yeah, but he knew when she said something that she was lying. Well, he says he he says he didn't. And apparently in 2024, you didn't actually have to investigate the truthfulness of your uncredible client, and now you do. Over the last 50 years, the United States Supreme Court has never approved that argument. To the contrary, each time the same or similar issue has arisen, the Supreme Court has rejected it. Well, you're stating things that didn't actually happen. The court held Arizona could not condition admission to practice of law upon surrendering First Amendment freedoms. The court likewise recognized that attorney disciplinary rules remain subject to First Amendment. The Supreme Court rejected the argument that attorney speech receives diminished constitutional protection simply because the speaker is a lawyer. We're just saying, as you're being a lawyer. We have not in recent years accepted our colleagues' apparent theory that the practice of law brings within its comprehensive restriction, or that we will defer to professional bodies when those restrictions impinge upon First Amendment freedoms, and none of the justifications put forward by respondent suffice to sanction abandonment of our normal First Amendment principles in the case of speech by an attorney regarding pending cases. And that was the Gentile that he's gone over before. The Gentile court further explained that the limited attorney speech case applying different constitutional standards involved only two narrow categories. One, commercial advertising by attorneys, and two, restrictions on information obtained through the discovery process. Neither category was implicated in Gentile, so the court rejected the Nevada's bar position and held the lawyer speech was entitled to full constitutional protection because wide open balancing of interest is not appropriate in this context. Same rule applies here. Petitioner speech involved public criticism of a judicial conduct and other matters of public concern, not attorney advertising and not confidential litigation information. But he has put over confidential stuff that was supposed to be kept confidential. Consequently, the ordinary protections of the First Amendment apply just like it did in Gentile. I don't agree. Indeed, courts throughout the country recognize that same principle. The accepted legal principle is that if an attorney activity or speech is protected by the First Amendment, disciplinary rules governing the legal profession cannot punish the attorney's conduct. Wait. How do I do this? Okay. Copy. Let me see here, Rob. Okay, Rob, I just sent you a link. Indeed, courts throughout the country recognize the same principle. The accepted legal principle is that if an attorney's activity or speech is protected by the First Amendment, disciplinary rules governing the legal profession cannot punish the attorney's conduct. And then he states another case agreeing attorneys who make statements impugning the integrity of a judge are, however, entitled to other First Amendment protections applicable in the defamation context. To begin with, attorneys may be sanctioned for impugning the integrity of a judge or the court only if their statements are false. Truth is an absolute defense, but he didn't have truth. Or what he says, he doesn't have truth behind it. The First Amendment does not protect intentionally false statements and false statements made with reckless disregard for the truth. Truth is an absolute defense to any statement made by an attorney that impugns the honesty or integrity of a judge. I don't think that the attorney said that. I don't think the judge or the PDJ said that it didn't. Like all other citizens, attorneys are entitled to the protection of the First Amendment, even as participants in the administration of justice. Against this vast weight of authority, the state bar argued that the PDJ agreed that lawyers do not have the same or any free speech protection. No, the PDJ did not say that. The PDJ absolutely did not say that. They didn't say that lawyers don't have First Amendment protections. Oh my God. They are just lying and making up bullshit here. That argument was incorrect. And if it was correct, this court should revisit that erroneous rule. Riley involved alleged misconduct by a former prosecutor who later was elected judge involving comments he made during his campaign. In discussing those allegations, this court cited. She leave again. Oh, okay. Hold on. Hey, I'm going to let you read this next part. I need to go grab my headphones.
Sure. Starting with against.
So let me get it to that part, and I'm gonna zoom outward a little bit. Okay, so that, if you can read it. I don't know if you can read it.
Yeah, I blew it up.
Okay, I'll be right back.
Okay. So Riley involved alleged misconduct by a former prosecutor who later was elected judge involving comments. Oh, sorry, I got to close another one. Close that. Okay, sorry. Against the vast weight of authority, the state bar argued, and the PDJ agreed that lawyers do not have the same or any free speech protection. And that's a valid point because we've all researched it. It's true. They're held to a higher standard, in my opinion, because they are officers of the court. According to the bar, this conclusion was implicitly or explicitly supported by matter of James Lawrence Riley, 142 Arizona 604, 691, P.2D 695, Arizona 1984. That argument was incorrect, really. And if it was correct, this court should revisit that erroneous rule. Riley involved alleged misconduct by a former prosecutor who later was elected judge involving comments he made during his campaign. In discussing those allegations, this court cited a 1957 case from Missouri, Woodward and Ray Woodward, 300 SW, for the premise a lawyer is held to a narrower standard. I'll let you roll up. Yeah, the exploitations. I hear you. Hey,
Okay.
Ginger. You're fine.
All right.
Just
Hello.
looking at the comments.
So
Oh, sorry.
there was just a bunch of
Comments. I had the wrong screen up. Sorry.
Oh, you're good.
Okay. So these passing comments from Riley and Woodward were harshly criticized in a dissent by the Chief Justice, who warned they were inconsistent with both the First Amendment and the Arizona Constitution. The broad, sweeping generalities of these statements cast serious doubt on their constitutionality in view of the First Amendment to the United States Constitution and Section 6, Article 2 of the Arizona Constitution. If the court's opinion had limited itself to statements by the lawyer candidate which were false, misleading, or concerning pending litigation, I could have joined in that portion of the opinion. The holding that a lawyer as a candidate for judge may not criticize the decisions of a sitting judge, however, is neither in harmony with the First Amendment nor with the necessities of a free society.
Okay.
Broad strokes.
Does okay, all the best doesn't have it. Is Bolo gonna be nice to me?
Hey, Wallace.
Does not look like Bolo is going to be nice to me. So you went and picked up these papers, or somebody did?
Yeah, somebody did. I picked up, or I requested the documents regarding his DUI case, which is now pled down to a reckless driving. So I have those documents, as well as what's included as part of the plea deal, the requirements.
Oh,
Yeah.
nice.
So you can continue with this, and we can come back to that. Not a problem.
All right, let's see here.
I don't want to screw up your flow.
Viewed in context, it is clear Riley's court suggested that a lawyer is held to a narrow standard of free speech than a non-lawyer when discussing the judiciary was clearly incorrect when Riley was decided. Okay. That conclusion is even less debatable today in light of more recent U.S. Supreme Court authority, which directly rejected that holding. Again, Riley relied on a 1957 case, Woodward, which predated by decades later cases Baird v. State Bar of Arizona, Bates v. State Bar, and Gentile versus State Bar, which we've heard him cite those cases in everything he's done with this. Those more recent decisions from the U.S. Supreme Court firmly reject the concept that lawyers do not enjoy the First Amendment rights as non-lawyers. In fact, they say the opposite. They are just misconstruing what the PDJ said, because he seems to think that it means like just because he's a lawyer, he doesn't have any constitutional protection of the First Amendment, and that is not what the PDJ said. Said.
Hey, is it okay with you if I dual stream? Is that okay?
Yeah.
Thank you. I don't want to screw up your stuff.
I don't know how to do any of that stuff. I'll have to learn that one day. The Constitution does not protect the right of some to speak freely. It protects the rights of all. It safeguards not only popular ideas, it secures even and especially the right to voice dissenting views. Consistent with these principles, our precedents have expressly rejected the notion that professional speech represents some separated category of speech subject to diminished constitutional protections. Well, then you know what? Just let all the lawyers go into court and tell the judges off. Just everybody go and cuss out the judge. And then you can say, well, it's my First Amendment right.
Yeah, I say nay to that.
I don't think that's going to work very well. I think a lot of people will be needing to bring their toothbrushes to court to go to jail because you'll be held in contempt. In its dispositive motion, the bar never discussed any of this authority, nor did it explain why this case should be governed by 1957 legal standards rather than more recent Arizona and U.S. Supreme Court authority. In short, the PDJ misunderstood or misapplied Gentile. Accurately stated, Gentile stands for the opposite premise cited by the PDJ. Attorney is not subject to greater regulation than speech by others unless the speech falls into one of two categories, either commercial speech by attorneys or restrictions upon release of information that the attorney could gain only by use of the court's discovery process. Neither of those categories applied here, so Mr. Gingras's speech was like in Gentile, except for his speech is false, and he doesn't have a factual basis for it. Entitled to full constitutional protection, the PDJ's contrary holding misapplied Gentile and must be reversed. Because the PDJ applied an incorrect constitutional standard, judgment on the pleadings must be reversed. Once the correct constitutional standard is applied, the lawyers do have the same free speech rights as others. The bar's argument fails. Petitioner's answer disputes the truth and falsity of challenged statements, alleges they were either true or constitutionally protected opinion, and raises additional constitutional defenses, both under the United States and Arizona constitutions. Those allegations created factual disputes that could not be resolved on the pleadings. I don't think he had factual disputes because the state bar was like, he did these things. And Gingras is like, I did, but. And it's like, no, that's not how that works. You did the things they're accusing you of, correct? Yes. But it's not fair. I'm like, okay, that's not. You're saying you broke the rules. You said yes, you broke the rules and a lot of those things.
It's as if he speaks out of both sides of his mouth at times, you know?
He does. I mean, free speech rights for him, but no free speech rights for you. You don't have to comment on that, but you know.
Well, like I said, you know, officer of the court, I don't think anybody in the general public is accountable for things. But when you have an officer of the court, the judge, anyone in the legal system, it's just common sense. You'd be held to a higher standard, right?
Right.
Like not drinking behind the wheel, driving, anything that causes a life to be in danger. Those are just examples, you know.
Yeah. And then I just like, it would be one thing if there was some solid proof of something. Like, if he had any solid evidence, then maybe it would be different. But he doesn't have any solid evidence of the things that he says. And so that's where the issue is.
Yeah, and as we've seen, lawyers can pull back from the 1800s, some court case, right, and reference that and make their argument. It's totally their right, and that's what a lawyer does. But that's as much as he can do, is pull from court cases or Rule 26 in some cases, right? But like you said, he doesn't provide actual tangible evidence.
No. And to me, it is reckless disregard for the truth because he's just saying it to say it. It wasn't like he had overheard a conversation or got a recording of Judge Mata saying, oh, I really love that bachelor, so, I'm just going to rule in his favor. If he had something like that, and then he wanted to say she was a biased judge, then I
Right.
would be like, absolutely.
Well, he did try it with her father, right?
Right.
Oh, that's an angle that you can attempt to try, but he must have spoken to her. She must have spoken to him. It's her father. Andy showed up for the trial. Well, that's any concerned citizen who is interested can attend a public hearing, right?
Right.
So there should be no issue there. But he did try to spin that into something worse, as well as, I want to use the right word, diminish Judge Amato's role and character.
Mhm.
Is that a good way
Yeah.
to say it? And
Yeah.
repeatedly would not stop.
And and to me, one being in a court filing, the look at me, daddy, I'm a real judge now. Like
Yeah.
that one cannot be a matter of free speech because there are restrictions in the court.
Mhm.
And that is an in-court document statement.
Yeah, it's public.
That wasn't just him in his house making statements.
Mhm.
That was disrespectful on the record.
Purposefully, no less.
Mm-hmm. Attorneys do not, let's see, here's a state bar argued and presiding disciplinary judge agreed that an attorney's admission to practice law constitutes an agreement to accept restrictions on constitutional speech rights that would not apply to other citizens. Yet they do apply to other citizens. The PDG made point clear, a person is not required to practice law in Arizona. However, once one elects to do so, upon admission, the person has agreed upon these directives in the rules of professional conduct and restrictions on one's general personal rights. Yeah, just like girls twerking in their Chick-fil-A or doing booby bounces in the Chick-fil-A, yeah, you can be fired for it.
Mm-hmm. Yeah, how many times have
That-
we seen that where, you
Mhm.
represent the company you're working for, no matter how big or small, if you do something that's inappropriate or against their guidelines, right, their policies,
Right.
that's what happens.
You can be dismissed. And to me, that is what this is he could be dismissed as being an attorney for Arizona. Like Arizona would be like the company, like a Chick-fil-A. And if you don't adhere to those guidelines, then you can't practice here.
Right.
And to me, if he can do whatever he wants, then he actually will have more rights than
Right.
any other private citizen would have at a job.
Yeah, I don't think the overall laws that are in place are to protect just him. I think they're intended for the public and citizens
Right.
of Maricopa County as well as the state
Right.
of Arizona. And that's why you have the State Bar of Arizona having such charges against him based on a variety of things. And I did
Mhm.
list those, but I can't drop them in the private chat, so I don't know how to get them to you, just so you know. But
okay.
did you hear also that because of this filing, it puts the State Bar of Arizona hearing, if you will, postponed or held or not
Yeah,
able to go
it
forward?
puts it as a stay. Yeah.
Again, we've seen that before. Postpone, right? Find many ways
Right.
to do that. Why postpone?
Right.
But in some cases, I can see the logic, I guess.
Because this is going to be happening as well right now in like the Karen Reed Turtle Boy defamation case in Massachusetts. They're going to have a stay because they were saying, you're saying that these disparaging marks are not allowed to be said. And so they're going to appeal that up. And so that's going to stay that proceeding. It's happened in a couple of cases I've seen where that happens. They can refuse to stay the case as well, but
Right.
yeah, the judge is like, sure, let's see what the US or the Arizona Supreme Court has to say. And then I don't think if he doesn't like that, he's going to go up to the US. All right.
If his counsel
Arizona.
thinks he has a real case, they'll keep going forward. But I think this is just an attempt, in my opinion, to just hoard off the State Bar of Arizona hearing. That's what my take is. Because just because he
Yeah.
closed his practice as of July 1st does not mean he gave up his license. So
Right.
he can practice law. He just doesn't
he can
know
still
how to
practice law.
out of it, right?
Right. And he says, he's done with that and he wants to move out of Arizona and everything. I get him not wanting to have like a bad mark on his thing, but this
Well,
wasn't supposed to be important to you anymore.
right. And if you want to look at it a different way, his last case was a win. Why not just leave on that note?
Right.
That would have been a golden opportunity to step away, right?
Yep. Says that Arizona possesses broad authority to regulate the practice of law and to impose lawful ethical obligations upon attorneys, but that authority is not unlimited. Like every exercise of state power, attorney discipline remains subject to the Arizona Constitution and the federal Constitution. The rules of professional conduct do not supersede constitutional guarantees. Rule 41 recognizes as much. Beyond creating ethical obligations, Rule 41 also requires a lawyer to support the Constitution and the laws of the United States and the state of Arizona. It would be an odd construction of a rule to conclude it simultaneously requires lawyers to surrender the very constitutional rights they have sworn to support. Well, that's not what they're saying you have to do. You are misconstruing what was said.
It's their argument that they're putting forth and letting the courts decide if it's valid or not.
Yeah.
And that's why it sounds so farcical at points. It's like, did you really mean to write it that way? Is that what your intent is? Because you and I are just your basic folks reading it, and you're like making our heads spin, right? Not understanding what the intent is here.
I mean, I know what they're trying to do. I just don't know that it's going to stand for it. And I think he has fudged up some of the facts.
One too many times.
And the interpretation, and he's saying things the PDJ judge did not say.
Right. Which is also might come back to bite him, because currently it's just in pending status, right? At the Supreme Court level. It's in pending status. So it hasn't moved forward yet. It just filed one on the 22nd. So
yeah. And they can choose to accept it or not accept it. I think they probably, this one, while I don't know, I can see them accepting this one, just because it is on a First Amendment thing in Arizona, and it is like the first time, because, well, normally attorneys know not to behave like this, but
yeah, it could be one of those lessons learned too, by accepting this filing and then potentially tearing it to shreds with a no-go. That could tell other lawyers too, hey, heads up, right?
Right. The United States Supreme Court also rejected that proposition in Baird v. State of Arizona. Arizona refused to admit an otherwise qualified applicant because she declined to answer questions concerning her political beliefs and associations. The Supreme Court reversed, holding that although Arizona may regulate admission to legal profession, that authority is constrained by First Amendment. Well, I don't think it's important. I can see why, if the person was asked questions about political beliefs and associations, why the Supreme Court would say, no, you can't do that, because that has nothing to do, your political beliefs or like your religious association, that has nothing to do with you being a lawyer.
Yeah.
And so I can see why they said that.
Right? You share your thoughts or don't share your thoughts. Your political views, which he obviously has shared many, is not a factual basis to deny or not be penalized for. It's the other stuff,
Right.
you know.
Nobody's going to be like, "Oh, you can't be a lawyer because you hate Trump or you
Right.
like Trump, so you can't be a lawyer." That would be unconstitutional, and I agree. If
Yeah.
that stuff was being done in another case, I can see why they would say that, "No, Arizona disciplinary, you can't do that." So, I can see why that one, but that is not what we have going on here. But sure, try to make it fit. Supreme Court reversed the holding, may regulate admission to the legal profession. That authority is constrained by First Amendment. First Amendment's protection of association prohibits a state from excluding a person from a profession or punishing him solely because he's a member of a particular political organization and he holds certain beliefs. Yet nobody's trying to do that to Gingras here.
Not at all. Not that I
Nobody's
can
saying
see.
you're associated with this shit. So nobody's saying, "Oh, you belong to this club." No. Nobody's saying anything about you ranting about Trump.
We should
So,
go
I don't
back and
think that
find out. Don't they swear when they become lawyers, like the medical field have to swear, doctors have to swear an oath? I'd like to get the verbiage for that and see how that applies here, right? He might not remember because it was so long ago in 2004, I guess.
yeah, I don't remember what his oath would have been. Um,
I could guess.
and it might have been stated in the order that that was the oath that he took, so I don't know. I think I remember something like that.
Yeah.
And then they're talking about Bates v. Arizona, rejecting Arizona's attempt to enforce disciplinary rules in a manner inconsistent with the First Amendment. In doing so, the court reminded Arizona that habit and tradition are not in themselves an adequate answer to constitutional challenge. Thus, the State Bar of Arizona has attempted to subordinate First Amendment protections to its regulation of the legal profession. Twice, the United States Supreme Court has reversed that effort. Okay, I would say 2 out of 50 years or however long, more than 50 years, that
Right.
2 isn't that bad. I would like to see comparisons for other states.
But from a legal perspective, they can cite it because it did occur at least 2 times. That's my only take
Right.
on that, right?
Let's see. Gentile Nevada rejecting the very argument advanced by the State Bar here that attorneys possess diminished First Amendment rights simply because they are attorneys. Court stated, at the very least, our cases recognize that disciplinary rules governing legal profession cannot punish activity protected by the First Amendment. And that First Amendment protection survives even when the attorney violates a disciplinary rule he swore to obey when he admitted to practice law. We have not, in recent years, accepted our colleagues' apparent theory that the practice of law brings with the comprehensive restrictions, or that we will defer to professional bodies when those restrictions impinge upon First Amendment freedoms. That language leaves little room for doubt. Whatever ethical obligations accompany admission to the practice of law, the surrender of First Amendment protections is not amongst them. The Supreme Court reiterated the same principles more broadly only months ago in Chiles v. Salazar. The court again rejected the notion that professional speech constitutes a separate category entitled to diminished constitutional protections. The Constitution does not protect the right of some to speak freely. It protects the right of all. It safeguards not only popular ideas, it secures even and especially the right to voice dissenting review. You already stated this. Why are you repeating yourself? I do not like when people repeat themselves.
Yeah.
Hello, Ames.
And you're handing this over for a court judge or the Supreme Court to review. The redundancy of it all can be very bothersome to them, you know? Get in, get out, concise, right? That's
Mhm.
what you should provide.
Yeah.
But the rambling, it seems. Sorry.
The this isn't even half as bad as like the Carmelo Anthony ones. Those were painful because they just repeated the same thing for
Yeah.
like 100 pages, and I was like, oh
And
my God.
It's mind numbing. I know.
It is, because I'm like, you can only say it so many ways.
Mhm.
You could have shortened this and still gotten your point across.
Yep.
Let's see. PDJ erred by ignoring the greater protection provided by the Arizona Constitution's Speak Freely clause. As noted above, judgment on the pleading is improper unless the moving party shows the answer fails to raise any viable defense. Petitioner's answer asserted not only a defense under the First Amendment, but also an independent defense under Article 2, Section 6 of the Arizona Constitution, commonly known as the Speak Freely clause. The bar nevertheless sought judgment on the pleadings without ever addressing that constitutional defense, and the PDJ granted the motion without discussing it. Omission alone requires reversal. Is all of this talk, or
I'm
is
sorry,
any of
real
this
quick.
exhibits?
He submitted this because of the charges from the state bar against him?
Yes.
Okay. But they haven't done anything about it yet. They're just charges looming, correct?
No, they there was a partial judgment made.
Oh, okay. Because from my notes, the principal allegation was, and I'm using my own words, so please take that with a grain of salt, sloppy investigation and ignoring the red flags. He was accused of pushing forward without properly checking his client's claims and medical documents, even though they were clear warning signs that documents like sonograms and hormone tests might have been altered or faked. False statements and evidence. Ignoring protective orders, the medical records he released, remember?
Right.
Interfering with
But
witnesses.
he says all of it was free speech.
No. Sorry. Interfering
He
with
says
witnesses is not free speech.
He said everything that he did was free speech.
Just
Releasing
because
the
he
medical
calls himself a
records
free
is
speech
free
lawyer.
speech.
He thinks he knows everything about free speech. Okay.
Yep. His argument was that he is not charged with anything that does not involve free speech. Every charge is his free speech. And I'm like, okay, that's one way to spin it.
Right. Can I share this document? If I go to here to, that's a page.
Yeah.
That wouldn't, I'd have to do an image. Let me just try this. PDF it. File. PDF. Doot. And doot. Okay. So then we got that. PDF.
So it basically says unless both defenses failed as a matter of law, judgment, or on the pleadings were improper.
I don't know if those will pop up on your screen or you have to allow it.
Let me see here. Oh, okay. We'll add this to the stage. Okay.
So let's come from the concept of First Amendment coverage, right? These are First Amendment is what he's standing on. Everything applies, is covered by First Amendment rights.
Right.
Starting off the first one. How is that First Amendment related? And if you go to the bottom, the last one.
Well, he says that the first one,
yes,
that Patrick and Bruce helped him out here because he didn't have to investigate back in 2024 things that were possibly false. He didn't have to do a thorough investigation to make sure that they were credible and legit. Because there was a rule that got turned, or it's not turned, but it's been updated, that now says they have to do an investigation.
and that's
But when this trial happened,
Yeah.
Right. And so he says that it was not required of him to do that, and that
So I
he
hear the
didn't
words
present
at the
any of this
time,
stuff.
right? The Supreme Court's decision will be at the time this rule or law was not in place. You were expected to do such, such, and such. You know what I mean? I don't know. We'll see
Right.
what comes out of the response.
Right. And then the last one, well, he argues, that he has the right to do that, and it wasn't a waste of time and resources, that they were actual legal claims, they weren't meritless. And he doesn't care what they said about the appeals motions, that they had merit. And I'm like, except for nobody says that.
Right.
And his interfering with the witness, like his witness intimidation, he
Mhm.
says he was using his right as an attorney to enforce a legal protection order.
Oh, from
And so
California.
he was petitioning the government then.
And that was in California. It wasn't even based in Arizona, correct? That protective order?
Yeah, but it covers all 50 states.
Okay, gotcha.
But the thing he does with that thing, he says it's not a valid subpoena. It
Mm.
is a valid subpoena. It is not a enforceable subpoena.
In certain situations, correct. Just like Judge Amata said, I want him here, or allowed him to be there as a witness, right? That's what we're talking about.
Well, he can come on it because he can voluntarily come to a subpoena. But it wasn't enforceable, because to make an out of state, like if somebody wanted me to go and testify as a witness in Arizona,
Yes.
then they could subpoena me. But unless they have the state of Texas subpoena me for Arizona, it's not an enforceable subpoena, because you can't force out of state witnesses to an out of state case. They
So you
can
have to work with
voluntarily
this.
agree to do it,
Yeah.
but he's saying because it was just a voluntarily, like, and not an enforceable subpoena, that he's saying it wasn't valid. And it's like, no, it was valid. He's saying because it was voluntary and they didn't get the state's permission for
Yeah.
him to come to out of state, especially with that protective order. He says they aren't allowed to do that. And it's like, no, they are allowed to do that. But if Maricini wanted to be like, I don't care what the subpoena is, I'm not coming to talk about this case.
Right.
Like if they tried to subpoena the other dude that wants to have nothing to do with this, he could be like, yeah, I'm not coming. Unless you like make my state tell me that I have to go, I'm going to wipe my butt with this.
That's interesting. So there's a process in place from state to state
Mhm.
levels to be able to
Right.
subpoena or mandate someone show. Okay.
Right. And that's why she couldn't do anything about the subpoenas for like Greg, is
Mm,
because that one was enforceable because he lived in that state.
gotcha.
Because I always wondered, okay, well, she has a protective order on Greg too. Why wasn't she doing that one? And then I was like, it's because that subpoena is valid and
Wow.
enforceable, whereas Mike's living in a different state was not.
Right.
So they used what they had. And then, yeah, all the other ones, he's like, First Amendment, First Amendment, First Amendment. I'm like, oh, okay, sure.
Yeah, that was my pull together, just so we have a, a quick view of what the state bar is allegations are.
Right.
And as you
Mhm.
just did, you kind of applied that whole whatever they put together to tie it back to these. So not
Yeah.
all of them are First Amendment related, which is good to know, but
Yeah.
they're focusing on the First Amendment ones thus far, anyway.
Right. So the online public attacks, First Amendment. Petitioning is a First Amendment thing, which was the interfering with the witness. He says that was petitioning, which is First Amendment. That it is, Laura Owens' right to release her own medical documents if she wants to. And then, of course, the false statements. He says he didn't do any of that because he didn't know, because he didn't have to do an investigation. He just took her word for it, even though she wasn't credible. But I forget which law it is that was changed.
Yeah, I'd have to check.
Bruce would know. It's Bruce and Patrick that came up with that. And Gingras was like, oh, after he was like, oh, dead moose. And he's like, actually, thank you for that, because y'all are right. I have a defense that I didn't know I had. I'm like, oh, but we're all stupid, right?
Yeah.
Oh, I have no idea about tax percent over in Brazil. I don't know anything about all that. Okay, let's get back over to this real quick.
ER 3.1. It's an Arizona Ethical Rule 31. That's just a quick check.
Yeah, because I think he mentioned it in a new one of his other pleadings, one of his new motions, and I believe he mentioned it in a blog. Which one it was?
Okay.
I just don't have those at my fingertip, and I forget the date that it went into effect.
This was written December 5th, 2024. The state's high court on December 4th agreed to narrow the ability of those not directly involved in legal matters to pursue ethics complaints against lawyers despite concerns it will lead to less transparency. The new rule, in essence, creates two classes of people who can ask the State Bar of Arizona to determine whether the actions of an attorney violate a host of rules that govern how they are supposed to conduct themselves. These range from financial misconduct and conflicts of interest for filling frivolous litigation. And that's from Arizona Capital Times, giving them credit. So I assume that's the rule. It does sound like an ethical issue, you know.
Let's see here. It might be that one. I think it is. Okay.
Yeah, it looks like they're referencing Arizona Supreme Court Justice Ann Timmer. It's a lengthy article, but there's certain things, Ducky, that should just be blatantly obvious to any and all lawyers, right?
Right.
It just mind boggles me that they don't take the step forward. Some, not all, because there are a lot of good lawyers out there that will do the proper steps and processes and verify, because again, you're hanging your hat on your client. What happens to them reflects on you. So you would think you'd want to do your due diligence.
Yep.
Not hide behind that was before me. That statement doesn't cut it in my book, you know. And for anyone who's practicing over 2 decades, I would think that you know what to do and how to do it. It's not just get my client off, but you want to do it legally and also leave them with some sort of reputation in place, I guess. I don't know how to describe it.
Yeah, but there are a lot of attorneys that will push the bounds, and
And when you
he
spin
will
out of
put
control,
them-
right? When you spin out of control over 2 years, almost 3
Mhm.
years almost, right? You end up putting yourself in this downward spiral that you can't get out of because you're in it, you know?
Yep. And he can't just admit that what he did, he should have done.
Mm-hmm.
He can't admit that he's wrong. He says that he admits when he's wrong, but he really doesn't.
Yeah, the apology video left me concerned as to his memory of what he actually said about people and what he did not really apologize for. That was concerning to me. I
Yeah.
don't know if you recall that. It's just like, no,
Mhm.
literally state what you said and apologize for it. That would be truthful enough for people to accept. But,
Yeah.
and with everything else going on the last couple of months, I truly thought he'd have a different mindset or viewpoint on life, you know? And if he is getting out of the legal business, let's say, right? What does it matter?
I think it's just because he doesn't want this bad mark on his
For future job
record.
opportunities, right?
Yeah, maybe for California.
Okay.
I don't know.
Then why doesn't he just give back his license on his own? Can he voluntarily do that
You're not supposed to be able to while
during
pending
a state bar?
disciplinary thing. Yeah.
Gotcha.
What is this? Who are these people? I don't even know who they are.
Who are they?
Okay. So he says, that plaintiff is seeking judgment on pleadings must demonstrate the defendant's answer fails to assert any legal sufficient defense. Well, I think the judge said that it wasn't legally sufficient.
Mm-hmm.
The court has repeatedly recognized that Article 2, Section 6 may provide broader protection for speech than the federal Constitution. That's great for that. Just a few weeks ago, this court reaffirmed, oh my gosh, excuse me, that the Speak Freely Clause tolerates no censorship or restraint on protected speech except as permitted by the Constitution itself, and emphasizing Arizona's long-withstanding commitment to robust protection of expressive rights. Article 2, Section 6 ultimately affords broader protection than the First Amendment under the particular facts presented here is a question this court need not resolve at this stage. The dispositive point is narrower. Petitioner's answer expressly raised the Arizona Constitution as an independent defense, yet neither State Bar nor the PDJ analyzed the defense or explained why it failed as a matter of law. The issue was simply not discussed at all. I think it's because you admitted to facts. Accordingly, if the court were to conclude the petitioner federal Constitution defense presented to a close question, the unresolved defense under the Arizona Speak Freely Clause independently precluded judgment on the pleadings. The order granting partial judgment on the pleadings, therefore, should be reversed. PDJ's and anti-SLAPP ruling must be reversed. So the order denying petitioner's anti-SLAPP motion requests upon the same erroneous constitutional premise discussed through this petition, the lawyers do not have the same or any free speech rights as non-lawyers. That is not that is the part that pisses me off because it's not what it was said. Keep saying it doesn't make it true.
Right, just because you say it and wrote it down. I read it somewhere.
Having concluded that attorneys possess diminished First Amendment protections because they are licensed to practice law. No, you can have a license to practice. But maybe you can't be admitted to the bar.
Right. And you may be book smart, but you might not be street smart.
You can pass and become a lawyer, but that doesn't necessarily mean you get to practice there.
Yeah, and there's a variety of ways to practice. You could be a corporate lawyer. You can be, a
Well, if he loses his
trial lawyer,
license, he can't
lawyer,
can't
right?
practice any of them.
Mm-hmm.
And there are people that have graduated law school and they are not licensed to practice law.
You think because they couldn't pass that final test?
Yes,
Okay.
because they didn't pass it, or, they're just like, they let their license lapse or whatever,
Yeah.
you know?
Right.
The PDJ further concluded that Arizona's anti-SLAPP statute could not constitutionally apply to attorney disciplinary proceedings because doing so would improperly restrict this court's authority to discipline lawyers. Both conclusions are incorrect. Well, they have to be able to discipline lawyers for their behaviors. Not even just the words that he said, it's his behaviors as well.
Right. As I stated earlier, they are representatives of the court. They're officers of the court. That's how they're referred to, but not often people hear that. But it's so true.
Right. Yep, that's why they're supposed to be candor, and he has not had any candor with the court about things that he knows are, and he says he doesn't have to apply candor because the case was over. So he didn't have to be candid about Laura and the Los Angeles stuff, or the fact that it was, her sister in the video of Ron touching the belly. He didn't need to be candor about any of that because the case was over when he supposedly found out.
Which is that gray areas that lawyers know how to play the technical aspect, right? Like technically, it was over past the case time, so I didn't need any.
And I do get it because everyone deserves a defense, and that I get there's criminal defense lawyers that are like, I don't want to know if you did it or not. Do not tell me, because if you tell me you did it, I can't go in there and say that you didn't do it.
They're there to fight the law. They're using the law. That's what we're focused on, right? What's legal, what's not legal.
And sometimes you have a case with bad facts, and that's just what he had. A case that it wasn't going to win.
Mm-hmm.
You didn't have the facts, you didn't have the law on your side with it either, so you just pound the table.
Right.
And attack.
So this was an appellate special action filed in the Arizona Supreme Court. It's in pending status for my research. And the special action challenges the adverse rulings made by the presiding disciplinary judge in the PDJ case number, because now it's a predecessor to CV-26-0236-SA, which is David S. Gingras versus State Bar of Arizona. So it supersedes it. Okay.
Right.
And Gingras asked the High Court to review issues concerning attorney free speech rights, the applicability of Arizona's anti-SLAPP statute, ARS Section 12-751, to administrative bar proceedings, whether truth serves as an absolute defense against charges of impugning judicial integrity, and whether attorneys completely surrender constitutional protections upon admission to the bar.
Yeah. And the thing is truth. And Gingras does not have truth in this.
If he's trying to make a name for himself so he can go out with a bang, I don't think this is it. Let me ask you this question. On Article 2, Section 6 of Freedom of Speech and Press, it says, I found this thing. Every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. So I read that as saying you can do what you want, but be ready for any repercussions if you do go past the line, right? Does that make sense?
It's not free of, they're not free of consequence. Just because you have the right to do something doesn't mean that you are free of consequence. And a lot of people seem to think, oh, it's my right, it's my right. Yeah, but it can have consequences. Maybe you can't go to jail over it sometimes, but you can be sometimes sued for monetary damages and
get
certain things.
Right. And you end up on your record. So that doesn't help.
You can't just do anything that you want. But you do have
the fire in a movie theater, right? That's a blatant great example, right? You can't do that. freedom of speech.
You just have to. You're free to do it. You are. I mean, you're technically free to go out and murder somebody,
Right.
because you wanted to. That doesn't
Right.
mean that there's no consequence for it, but you are free to do it.
Yeah.
It's just not a great idea,
Right.
and it is against the law.
Yeah.
But sure, I do not
Right.
promote that. Nobody go out and do that. Do not
No,
kill
don't
people.
do that. But it's just an example. She's just sharing an
Mm-hmm.
example, just like yelling fire in a movie theater. You're going to cause such a horrible situation, and that's why
Yeah,
it's
people
used so
could get
often.
injured
as an example.
and things like that. Yep.
Mhm.
It's just okay. Now he's going to talk about chilling speech. So,
Oh gosh.
Arizona's anti-Slapp statute reflects the legislator's determination that meritless governmental proceedings targeting protected speech should be dismissed at the earliest possible stage. Disgusting newly expanded version of ARS 12751, which maybe this is what he was talking about.
Yeah, section 12-751.
They keep well, no, because this is a fairly new statute as well. I think the anti-Slapp is new in Arizona. A lot of states have it, but there are some states that don't have anti-Slapp.
Okay.
I was thinking maybe that was the one that they were talking about, but it wasn't.
Protects people.
And noting the
people from
expense
lawsuit
of defending
and to stop their free speech, freedom of the press, and other constitutional rights. It lets a person file a fast motion to dismiss a case if the lawsuit tries to punish them for exercising these rights.
Right. So let me see here, because like if Laura tried to sue us for making statements, like anything that I said anyways, and I have a reasonable factual basis to say it, or something is my opinion, then I could file an anti-Slapp against it.
Okay.
And I wonder, does Texas have anti-Slapp? Of course, Texas has anti-Slapp. We're like, no, Texas is like, we're free range here. We're going to do whatever we want here in Texas. We like pew-pews and all the other things. I don't necessarily care for them, but.
Right.
Okay. Noting the expense of defending a meritless case can have a chilling effect on First Amendment rights. Courts must therefore act as gatekeepers, protecting the right to free speech from encroachment. Citing some more civil type cases. There's some law cases. To accomplish that purpose, the legislator expressly extended the statute beyond civil lawsuits to include any regulatory or administrative action by a state actor. Then they cite the ARS 751 and exactly things. Although this new provision has never been interpreted by Arizona court, the plain language of the statute encompasses attorney disciplinary proceedings brought by the state bar. Other courts with similar laws agree they apply in attorney disciplinary cases. If I would have kept reading, I would have found out that Texas has anti-Slapp.
Right.
Let's see. Applies to the commissioner's disciplinary proceeding against an attorney. Okay. Agreeing TCPA applies in lawyer disciplinary cases because the TCPA was enacted to safeguard the constitutional rights to petition, speak freely, associate freely, and otherwise participate in government from infringement by meritless lawsuits. Whoa.
So in Arizona, anti-Slapp has been around since 2006 when it originally became law. It was expanded in 2022 with amendments. So it has been around.
Okay, maybe it was that it got expanded recently.
Yeah, the expansion. Yep. And
Yeah.
recently faced high-profile court challenges regarding its constitutionality. Okay.
Because we have to remember this case was going on in like 2023, 2024. So
Yeah.
even though it's 2026 now, 2022 was fairly recent when all this started.
Yeah. I just came across an article and it says literally the first words are in the age of instant social media.
Yeah. Well, you know, I don't know if you saw Arizona State University, ASU,
Yeah.
now offering influencer degree. I'm like, oh, great.
Yeah. Look at the next generation, right?
Something we don't need more of.
If we ever lose electricity, if something happens on the earth, all this goes for naught. Nothing you've done, nothing you've written or posted, it all goes away. So, but
Yeah.
social media provides like it said in that article, like you just said, I should say, an immediate update or information sharing versus waiting for like the 6 o'clock news from the old days, right? Even the news channels have channels on social media. Lawyers have channels on social media. It's not going away anytime soon, and it has grown so much in the last decade, or longer. Hey, Treat Fairy, how you doing? So what else can I share about that? Complaint.
Okay. I had to plug in my computer. I am so not with it today, but I worked and I thought I was getting up earlier than I was. And so I was like, oh, dang. Okay. Let's see what else we've got here. Just a stage. Ba-ba-da-ba-da. PDJ nevertheless declined to apply the statute, reasoning that it would unduly hamper the judiciary's authority to regulate attorneys. That conclusion misapprehends both the scope of the legislator authority and the strict constitutional limits upon the judiciary's disciplinary power. To be sure, the court possesses exclusive authority over the practice of law in Arizona, but that authority does not exist in constitutional isolation. The legislator may enact statutes affecting the practice of law and establishing procedures for enforcing rights so long as those statutes do not conflict with procedural rules promulgated by this court. And case law. Oh my God, I thought I was almost done. Nothing in Arizona's anti-Slapp statute conflicts with any rule.
Cases they cited.
Cases?
Yeah, they're just above right there.
Sizinger v. Seibel.
2005, 2023. Okay. So they're relatively new, nothing ancient.
Yeah. But the thing is, are all of these attorney ones? Because like I said, I don't really care if it is a criminal case or a civil case. I want to know about attorneys, like disciplinary cases with these standards. The rest don't really apply to this because it's not the same jurisdiction. Nothing in Arizona's anti-Slapp statute conflicts with any rule governing attorney discipline. Rather, the statute supplements existing procedures by providing an early mechanism for dismissing proceedings that impermissibly burden constitutional protected speech. Because no conflict exists between ARS 12751 and an existing rule governing disciplinary proceedings, the PDJ has no basis for declining to apply the statute. Well, they said that as the way that it's written right now, that they don't think that it applies that way. And she was like, if you want to appeal it, then you can appeal it to get a more clear, so we can have a more clear understanding of what they are allowed to do and what they're not allowed to do.
That's basically a question, not so much
right.
Go do it and can find out later if it's okay.
That's why I'm like, you know what? I'm not necessarily mad about this. just because I am interested to see, at least in Arizona, if his speech is constitutionally protected speech. And I think they have to look at his speech specifically and not just in general,
Right.
because they're just talking in general. I think Bruce said that, he's just bringing up that lawyers should have protected speech, and it's not that they don't. It's just the things that he did are not protected by that.
As
They
implied
don't
through
even
their filing. Yeah.
right. They don't even talk about Gingras and what he did and what he didn't do and things he said in this. They're just saying that lawyers, like all citizens, are entitled to the protections of the First Amendment.
So I found a
And that's
state versus
basically what this is.
Michaela Court in April 2024. The county attorney, sorry, I just hit the screen. County attorney led by Rachel Mitchell charged the court and dozens of other individuals for criminal trespass. This is during the pro-Palestinian protest at ASU Tempe. And then it states the anti-SLAPP twist. Arizona is uniquely one of the few places where the anti-SLAPP statute applies to criminal prosecutions as well as civil suits. The defendants filed motions to dismiss under the anti-SLAPP law, arguing the criminal charges were substantially motivated by desire to deter, retaliate against, or prevent their lawful exercise of First Amendment assembly and free speech. So that would be a good one he could have referenced.
That does not stand for his proposition. That would be a good one for the bar to state, because it says criminal and civil, not an attorney disciplinary hearing.
And that's what I looked for. I was just trying to find something with attorney.
And I think that's what the judge said. As it reads right now, it's for criminal and civil. It doesn't state that it applies to this. Because I think he would have the protections if he just went on the street and was acting as himself and went to, let's say, Scottsdale Police Department and was just like, y'all suck. Y'all do shitty investigations. You didn't even see a person when you did a wellness check. I think he would be free to make those if he's just making them as a private citizen, not as anybody's attorney. And even though he is an attorney, he can make those statements. They have some factual basis, and he is criticizing, a government authority. It would be petitioning and things like that. He would be fine.
Yeah.
But this is not that situation. And they're trying to say, oh, he has no protections of First Amendment because he's a lawyer. No. Nobody said that.
They could hand hard heavy spinning it in that way so that they take a second look. Yeah.
They're spinning it and being disingenuous.
There you go.
They keep talking about, okay, civil rules. Well, this is not a civil case. Rules of civil procedure. I don't care about those. They think that it needs to be reassigned. If this court grants relief, it will necessarily reject the legal premise upon which those rulings rested. Reassignment would permit the remaining proceedings to occur without requiring the same judicial officer to accept a constitutional position she has previously rejected and reaffirmed. I don't think that there would need to be a new judge. I think this judge ruled based on what the law is right now. And she has even said, you know what, this might be a case. This is a case of first impression. The judge has said that. And if the Supreme Court were to come back and tell her, no, this is what this is, she would apply those things and rule the correct way. But they don't want this because they're like, no, she's biased. She's not going to agree whether the Supreme Court tells her she's supposed to do something or not. She's just going to do whatever she wants. And it's like, no. So as soon as this is done, And if
Yeah.
they are right, they want a new judge for the disciplinary proceedings.
But it's just, once again, it's a stall tactic, because if that works and they get a new judge in place, they're still going to review the evidence, black and white, right? No emotion, and the decision's going to come out potentially the same. There's Court, yeah, Michaela Joy Court. They did reference it.
Yeah, that was one that I was going to look at.
Yeah.
Ooh, I can't click on any of those. Dang it.
Yeah, that was the on ASU's campus in Tempe, the Protestant, right?
Do what?
Pardon?
What did you say?
Oh, I said that's the case I was talking about a little bit ago, and it was.
Oh, okay.
Yeah.
Because that was what the court. That was
State
going
versus
to be-
Michaela Court involving 68 total defendants. So 67 other protesters facing criminal trespass charged by the Maricopa County Attorney's Office. And that was
yeah, that was the case I was going to look at because he does have it cited.
Yeah, pro-Palestinian protests at ASU Tempe.
And I don't see what that necessarily has to do with.
Yeah, that's assembly, which is part of First Amendment, but that's not what this
I don't think that has anything to do with an attorney. Was it an attorney? Was one of the people an attorney?
The summary I have.
That one deals with the prima facie, which he didn't make a prima facie showing, which he was supposed to do, and he didn't. If he did it, he didn't do it well.
Right.
So I don't even think that case actually applies to. There's a lot of cases he cites that to me don't apply to this. And then let's see if any of these 751.
Yeah, for the State versus Michaela Court, there's a Justice Court lower court case number, a Superior Court special action level case number, and Court of Appeal appellate level. Do you want any of those case numbers? Would that help you or no?
No, I haven't.
Okay, gotcha.
I was seeing if I could find. This is not what I want. If his index was clickable, that would make things way better because I know what motion I'm looking for.
Yeah, I hear you.
What is this? But notice they didn't mention in any of that what Gingras was doing himself. Like they didn't say, well, Gingras, when he said that
specifics,
this judge did all these bad things, that they didn't mention any of Gingras' statements that fell under that anti-Slapp. They didn't bring up anything he said. Yes. Yeah, it's in exhibits and all that, and they're going to have to figure it out from the exhibits, which one of them is 328 pages. There's another one that's 146, and then there's another one that's in the hundreds as well, plus this 40, the 40-page motion, basically.
In my opinion, that's not a good way to get the courts to side with you.
So they can decide in a matter of law whether attorneys have, but they're going to be like, yes, attorneys have First Amendment protections, but, so you're right about that, but in this case with this dude, these are the unprotected acts.
And
maybe they'll say
act individually to defend it, right? He knows the charges. We know the charges.
Mm-hmm.
There are 6 of them. So why not address that instead of a blanketed First Amendment stance?
Yeah, I just think they're just doing it as in general, but not actually appealing in regards to his statements.
Right.
And I think that's where this needs to be done. It needs to be about his conduct and his statements, which is what the exhibits and stuff are for, but not once did he mention anything. I mean, he mentioned Gingras's name, saying, "Oh, that's what Gingras is doing here. He has those rights," but like, how many times does he even say Gingras?
Oh yeah, good point.
10. One is in. Okay, one is like the attorney for petitioner and who the person is. So, okay, that's 2 is that. Okay, 3, that he is the disciplinary person in this, and that Gingras has been licensed to practice law since 2004.
You were going over the petition, correct?
I believe so.
Okay.
Yeah, petition.
Got it.
Yeah, okay. So then was not accused of participating in or having any knowledge of any alleged criminal conduct. Mr. Gingras engaged in several forms of speech that later become the subject of disciplinary proceedings. Maintained statements were factually true. And then one, his name is mentioned for a petition or an exhibit, basically. He says his speech was like one of the cases, like maybe 5 times through the 40 pages that aren't like just one is in the this is who this is for. Then some of it's part of a motion or an affidavit that was submitted previously, but like 5 times in the actual motion, maybe. It just does not pertain to any of the statements and anything that he's actually being disciplined for. It is just a general thing. Why? What are you making? Mm-hmm.
It's like meat, potatoes, pepper, onion. You can put olives in there, no olives, rice, salt.
I'll look at it when I come out. But thanks. Apparently my daughter and her boyfriend are making something, and I'm like, I will see what that is later.
Stay away from the stove, stay near the door.
Well, she's an adult, so.
Still. Mom's always worried.
It smells good, though. But I may not eat everything that's in it. I mean, most people would probably like it, but I'm a little bit picky. Okay, so that is that. And I don't think the rest of it was mainly just exhibits and transcripts and different things like that. I don't think there was anything else that was like mainly filings. But you said you had stuff?
Yes. Let me open that up.
Or stuff anything you wanted to share. Like, I'm open for that.
Sure. Let's do this. So I have 1, 2, 3, 4, 5, 6, 7 documents. Based on the docket from the city of Scottsdale. And I hadn't been collecting them since the May timeframe. So I just requested all of them at once, and I got them the other day. So let's share there. Let's see. I need to do this right. So let's go here. I'm going to put numbers so I can put them in order. 2. I should have prepped more. Sorry. 3.
Oh, you're good.
Yeah, this is regarding the motions and the plea deal acceptance and the reduction in charges to what he actually pled guilty to, which is the reckless driving.
Mhm.
And what that does is it identifies his requirements that he has to fulfill. And then I looked up what if any of these are not fulfilled, right? And what the repercussions are. This is the gotcha. I like this one. That should be that. That should be that. Okay. And let me get rid of this number. And okay. 1 through 7. And I can open this up now. Okay, got them there. So now when I go to share, oh, these are images. Do, do, do. I'll put it on my desktop so I can find it quicker. There it is. And I don't know how many I can do at one time.
Mhm.
That one. Image. 2. No, one at a time, of course. So I have the number 1 in front of the word screenshot, and then 2 and all the way. So if you want to pull up that first one, I'm going to keep adding them to your
Okay.
view.
So this one.
So notice of right to apply to have convictions set aside and certificate of second chance, and to petition to seal criminal case records. And he signed off on this on May 22nd, which was the day of his plea agreement.
Mhm.
And I don't know if you want to read that verbiage. I don't know if that's
So let's see. Eligible for second chance, you can file application yourself. If you have an attorney or person, they can file application on your behalf. Additionally, once you completed all conditions of your sentence or probation and it's been discharged by the court and required time has passed, you can petition court to seal the criminal case records, including the records of the arrest, conviction, and sentence. If you have cases in more in more than one court, each appropriate court must act on each case individually. If you have more than one case number, you must file separate application or petition for each case number. Note that the conviction or for certain offenses cannot be set aside, and the granting of an application to set aside a conviction will not affect your driver's license record. The court will not charge a fee for filing an application to set aside a conviction, certificate of second chance, or a petition to seal criminal case record. If the court grants your application to set aside, the court must include a certificate of second chance pursuant to ARS 13905K if you are eligible. The application to set aside the judgment of guilt, the application for a certificate of second chance, and the petition to seal criminal case record can be located on the website. And then he signed it on May 22nd, 2026. Okay.
so he signed that off on that as a
Right.
receipt by the defendant.
Mm-hmm. And then let's see, screenshot 2. This one was also signed on the 22nd. And this is the plea agreement. So the defendant agrees to plead guilty to amended count 1 ARS 28693A, reckless driving, a class 2 misdemeanor committed on July 6, 2025. The defendant shall, for count 1, pay a fine of $500. Any additional statutory surcharge and or court fee, which equals $1,068.61. I guarantee you he's paid that already. B, substance abuse screening / program. Defendant shall contact the program agency within 2 business days. Defendant shall enroll, maintain regular attendance, and successfully complete the program. Well, I'm glad he has to be in a program. 2, the parties further stipulate to the incorporation by reference of the department, and they give a number, for use in determining a factual basis. The following charges are dismissed, or if not filed, shall not be brought against the defendant. Count 2, ARS 28-1381A2, and count 3, ARS 28701A, which was probably the drinking and driving part.
Mm.
I don't know what those exact counts are.
What was it again?
ARS 28-1381A2.
Yeah, that's a knife. Put this over here. Minimize this. Close that. Yeah, I have the charges over here. I took back 3 documents because I didn't redact his address, so I don't want you to use those.
Oh.
So
Yeah, I don't
what
wanna
I'll
use
do
those
is print screen everything below it. Is that okay?
Yeah.
Let's do that. Okay, so this is 3.
So let's see here. 28, 13. $81A2. Okay. Driving or actual physical control while under the influence. So that he can't be charged with that. And then 28-701.
Here, I'll give you this one. Image. Charges.
And the speed. So basically a traffic violation, his speeding. So
Yeah.
that got dismissed.
I just
Speeding
added,
and
the document, the charges, just so you know, they have the list of the statuses with what he pled and what was dismissed.
Yeah.
I got 3.
So we got the reckless driving. The speeding one was dismissed, and the under the influence was dismissed.
Which is quite mind-boggling to me, right? Just in general, right? If you're over the limit, you're driving. How does that get?
They do it all the time. They do it with the first time usually.
Yeah.
But because it's his first time in a number of years, they're doing the same here. But if he got like a second one, like really close in time to this within like the 5-year period, it wouldn't be like this.
Okay.
I still think they should treat it differently because he's had one before, period. But that's just me.
Right.
Let's see. The defendant avows nada. If the plea agreement is rejected, withdrawn, or reversed on appeal, the original charges will automatically be reinstated and set for trial. Yeah, he's not allowed to appeal this, basically, or withdraw his plea. The defendant gives up all motions, defenses, objections, or requests that have been made or raised or could assert hereafter to the counts. Court's entry of judgment and imposition of sentence consistent with this agreement, Unless this plea is rejected or withdrawn, the plea agreement does not preclude any other remedies authorized by law. Motor Vehicle Division may take additional separate action that may affect defendant's driver's license and or vehicle registration. Yeah, they could suspend his license still because they don't have any control over whether the DMV allows you to have your license or not.
Well, he already went through that hearing. The officers did not show up, so it was dismissed. Through the Department
So
of
his
Motor Vehicles.
license is reinstated, basically, or his
Basically.
driver's license is good. It's
Yeah.
not suspended.
Correct. Okay, I'm adding 3A.
That's the easiest way to win a lot of traffic things is where the traffic guy, your police officer doesn't show up.
Right. Yeah, I was
They're
there.
like, I have something else more
important.
important to do that day.
Couple minutes, yeah. Okay, I've added 3A, 6A, 5A, and 6A. So it removed the top part, just so you know.
Okay, so 3A. So we'll go to that.
So the judge is the initials on the left. K-A-Y, first name.
Okay, K, yeah.
So here's the guilty plea proceedings.
I understand the nature of the charge of reckless driving, class 2 misdemeanor. The defendant appears with counsel. The defendant and the prosecutor have entered into a plea agreement, and the defendant understands and consents to its terms. The defendant understands the range of penalties can be maximum penalty of $750 fine plus subcharges and fees, 120 days confinement, 24 months probation, and a minimum penalty can be a suspended sentence. Let's see. Number 5 is NA. The court has advised the defendant that this guilty plea may result in violation, parole, or community supervision. Defendant was advised of the following: if you are not a citizen of the United... Okay, but they say that to everybody. We know Gingras is a natural born citizen.
Yeah, right.
The court has advised the defendant that this guilty no contest plea should result in collateral consequences, including but not limited to immigration. Okay. Defendant understands the following constitutional rights that they are giving up, which most of the time when you plead guilty, you give up these rights. Just like if Laura accepts the plea deal, she will be giving up these rights herself. She would give up the right to plead not guilty, and require the state to prove beyond a reasonable doubt, because if she admits guilt, the state doesn't have to prove she's guilty beyond a reasonable doubt if she takes a plea deal, because she's admitting she is guilty.
If she takes the plea deal, can she take it back later? No.
Nope.
Nope.
They do not allow that.
Gotcha.
Brian Koberger just filed trying to take his appeal
Yeah.
back today. That's not going to work.
Yeah.
One, he's not supposed to appeal certain things, but he's saying ineffective assistance of counsel. And I'm like, you had probably the most zealous advocates for you who filed every motion and did everything they possibly could.
Right.
But sure, I guess you're bored in jail because, I mean, what else do you have to
Right.
do in jail?
Have a right to file. So go ahead.
He's gonna be there, and he's like, you know what? It would be really nice to get out of prison and just go to court for a day again.
Yeah.
This cell is getting a little boring.
What shall we say? Prison life he's living after what he had been found guilty of.
Yeah, and I've heard it's not been easy on him.
I would think not.
That they would give up the right to a trial by jury, if any, or by a judge, because you're not going to get a trial if you take a plea deal.
Yeah.
Right to assistance of attorney at all stages of the proceeding, including appeal. In some cases, the defendant may be eligible for a court-appointed attorney at a reduced cost or at no cost if the defendant cannot afford one. That's not what we're dealing with here. in Gingras's case.
Right.
The right to confront witnesses against the defendant and cross-examine them as to the truthfulness of their testimony. Right. She
So
won't
this
get to
gives the
confront any
officers-
of her witnesses. Right to present evidence on the defendant's own behalf and have the court compel the defendant's chosen witnesses to appear and testify free of charge. That's what Laura would give up. The right to
Mhm.
have witnesses to come in and say, no, she's the most honest person I've ever come across in my life. Hoboken.
Hoboken.
I can't say it like Bacon does. Hoboken. I can't get my voice to do that stuff. Right to present evidence. Okay, we already said that. Right to remain silent, not to incriminate oneself, and to be presumed innocent. Yeah, you don't get to be presumed innocent anymore once you plead guilty to something. And a right to direct appeal. They can't appeal, like the appeal that they're usually guaranteed after a court filing. They give that right up. Now, Koberger, in his case right now, he is not doing a direct appeal. He is doing like a relief of something. Who else is doing it right now too? Mackenzie Shirilla is also doing it. It's not her direct appeal she's dealing with. It's another one that's like relief from whatever. I forget what it's called.
Roundabout, basically.
Mm-hmm. And then it says the defendant wishes to give up these constitutional rights after having been advised of them. A basis in fact exists for believing the defendant's guilty of the offense charged. The plea is voluntary and not the result of force or threats or promises other than those contained in the plea agreement. This is why when they're like, no, it wasn't voluntary, it's like, but I asked you, are you making this voluntarily, free
Right.
of choice? Are you saying you are guilty because you are guilty? And they say yes. And then they want to try to come back and say, no, I was
misunderstood.
coerced. It wasn't voluntary. And I'm you're like, but you said it was. So
Is
which
this what the Alfred questions that they ask? Is that basically what this is?
no. Alfred is where you are not admitting that you did it, but you are admitting that the state has enough evidence to prove that you did it.
Ah, gotcha. It's a gray area.
Kind of
but
like
pretty much.
it's kind of like a no contest, but where you're like, I'm not saying that I did or didn't do the crime, but I'm just going to just take my licking and move on because it's not worth fighting.
Right. Yeah.
Which I usually do, like no contest to like a speeding ticket if I've gotten one. I'm like, I'm not contesting this. I'm not admitting anything either, but I'm whatever. I'm just gonna pay my ticket and go on about my
Yeah.
business.
Get in, get out. Right.
Let's see. He also defendant may file Rule 33 petition for post-conviction relief, and if denied, may file a petition for review. Defendant may apply to the court to have a judgment of guilt set aside upon fulfillment of the conditions of probation or sentence and discharged by the court, and may be eligible for certificate of second chance. May be eligible for petition to the court for an order that seals the court record, which we went over that. After the required time has passed, the defendant is satisfied with the services of their attorney. And that's another one they usually ask so that when you try to come back and say, my attorney was shitty, it was ineffective. You're like, you said you were satisfied with your attorney and now you're saying you're not. Okay.
But that comes into play when you plead guilty or no contest, let's say. But if you actually go through a full trial, you can say you had ineffective counsel.
You can. I've even noticed even when people are doing like before they are going to choose whether they testify or don't testify,
Oh, yeah.
they'll be like, are you, were you satisfied with the conversations and with
Right.
the lawyers and stuff? And so there are ways that they put it in there so that when you try to claim that, it almost backfires because you're like, no, because you
Right.
could say, you know what? No, my attorney's advice was shitty, and
Mhm.
I don't know what I want to do because they're crappy, and I would like to fire them right now. And you're like, okay, but you're
Right.
going to defend yourself then. Let's see. On the basis of the findings, I conclude the defendant knowingly, voluntarily, and intellectually pleads guilty to the above charges and accepts this plea, which is the reckless driving class 2 misdemeanor.
Correct.
The defendant certified that the judge personally advised him of the nature of the charges, the range of the penalties, the constitutional rights as indicated, understands the constitutional rights which he gave up by entering this plea, a desire to plead guilty as indicated above, a desire to proceed without an attorney, or if represented, my attorney's signature appears below. So that was 3A.
And the date at the bottom, it's around May 22nd at about 9:15 a.m., 9:13 a.m.
Yeah, May 22nd as well. Where did number 4 go? Oh, here we go.
It's 4A now. Sorry. Or no, there's 4. It didn't have any information on it.
Oh, it doesn't?
Well, it didn't have any identifying redacted information I had to redact. That's all I meant. So 4 screenshot is what you're looking at. So that's
Okay.
basically a sign off.
Yeah, that's a sign off.
One judge and the defendant and the defense attorney.
Yep. They said there would be a signature. All right. 5A is.
So this is a minute entry from a different judge on the 20th.
Defense attorney's motion to accelerate. Defense attorney's motion to accelerate is granted. Okay. And that was on 5/20. So this was prior
Right.
to him accepting the plea. This was like,
Correct.
hurry up and get this crap over with.
Yeah.
Can we stop pushing it off? And you're like, weren't you the one that was pushing it off?
For a year and more.
Yeah. 5/20/26. And then this one, that's 6A. That's pretty much the same thing. And then screenshot 7. Report.
So as part of his plea deal, he needed to attend a treatment center for drugs and alcohol education.
Right.
And this is I think it's the contact report on a monthly basis. It was report date of May 18th. And it was stating that the schedule for intake starts on May 18th through completion date.
This was prior to him taking the plea.
And a completion date of July 18th, which was just a week ago or so, a little over a week.
I think my guess is some of this got extended out.
Well,
but he could have completed it by that date.
16 hours, right? And
16 hours
after
is
looking
nothing.
at their website, they also offer online, like Zoom.
Oh, yeah.
So it could have been
probably
handled
completed
here.
it.
I just did not see on the docket the final one stating it was completed. And I don't know if it'll be added or not.
Right.
But because this is still there without another one, it kind of leaves you in a gray area to know if it was completed or not, which I hope he did, because there's no reason to not do it. But it states in several places must be completed.
I mean, great. He had to take a program. It's to me, it's still not going to change his behavior. I wish.
But
but if he knew
by doing the intake prior to the plea, it could make the plea deal better. Like, see, I'm trying to get help, kind of thing. You know what I mean? Like,
a lot of people, they're like, see, I put myself in rehab.
Yeah.
prior to.
Right.
Hello, new peoples or people that I don't really know. Okay. And then
I added the case activity. Oh, yeah, there you go.
this was the charges.
That's where it lists the guilty for the first one, disposition description,
Right.
and the presumed fine amount, which on the next one you'll see the charges. The next one was dismissed,
Right.
which again, from my perspective, that blows my mind.
Yeah, I
And then
don't
the
like
last
that
one
one was dismissed.
dismissed.
I would have been okay with the reckless driving and this speeding one being dismissed, and then this one being the charge at the end of the day.
Yeah.
But of course, that's just not how they do it. And I wish they took DUIs more seriously than they do.
Yeah. After everything we've seen and heard and people have experienced and mad, mothers against.
Especially when he was like, it's not illegal to drink and drive. And you're right, it's not illegal to drink and drive. But it is illegal
To be over the limit.
to drink
per the
over the limit. And whether you feel like you're fine doesn't mean that your BAC
right.
matches that. There are plenty of people that feel fine and they don't feel intoxicated because their tolerance is very high,
Yes.
but they are definitely over the legal limit.
Right. And then a lot of them don't even realize that they are by their actions tells the tale,
But when you're like, oh, it's not illegal.
He was falling over trying to do the walk toe to toe, heel to toe. She kept falling over. So, and she didn't feel that she was beyond the point. So your judgment.
But when you're just like, oh, it's not illegal. No, but it's a bad idea and it's irresponsible.
Yep. And then the last one was the case activity that listed the variety of charges, amounts, and all of the funds they have to provide. The one that I looked up was first responder death benefit in Arizona, which may be in a lot of states. It's a mandatory payment that goes into, which is a great feature. And I'm glad that it was approved by the voters because so many people are impacted and are left without, their loved one and financial impact,
Yep. And a lot of times these are included in a lot of cases where you have to do I know victims' rights is always included, even though it's small. Victims' rights are
I see
always a charge for the court.
But nothing for MADD, correct? That I can see?
I think that's like part of victims' rights.
Okay.
But it doesn't go personally to MADD. It's just victims' rights. Gotcha. So there's two for an victims' rights enforcement assessment, and then $9 for victims' rights assessment.
In 2018 clean elections, that's not voting for the next politician, is it?
I have no clue.
Yeah, I didn't look it up, but I was like, election city attorney enhanced.
But there is, let's see, 1, 2, 3, 4, 5, 6 that fall under that clean elections thing.
Right.
6 different charges for that. One's only 14 cents though. One's 45 cents.
I'll take it though. And all that occurred on the 22nd of May, except for the very last one, which is someone who requested records received them. We'll leave it at that.
It was delivered, vacated.
Oh, and the 27th, the final disposition.
It doesn't say that it's been paid, though.
I do know on the site, it does not allow you to pay online. It literally states that you're not able to pay this online. So it either was go to the courthouse or pay to the attorney or something.
Because normally, I mean, he could have gone downstairs or upstairs or just
Yeah.
wherever. Because
Right.
sometimes they're like, oh, just go downstairs or down the hall and just, make a
Pay
checkout
them.
or whatever.
Get it done and over with. Sure.
But usually they're like, okay, fee has been paid and the balance is 0. But I don't know if the public can see that or if it's just the
Right.
person can see that. Because we don't know if he still has a balance or not. I would
Right.
assume he could have paid this very easily.
Right. I don't know how good you are with dates. Was there anything else going on around May 22nd? Wasn't there something else on that same date?
Of this year?
Yes. I'm going to go back to my calendar. It was a Friday. There was a CCMC on the 20th for his ex-client. And then the 26th was, I think, the original foreclosure of the parents of an ex-client.
Yeah, that was right before Memorial Weekend.
Yeah. Yeah, and that was just before I had my kidney stone surgery. I had 13 stones removed.
Oh, good God. I've had kidney stones. They're awful. My daughter had them when she was pregnant, and they can't do anything about kidney stones when you're pregnant. You have to just leave them.
Jeez. That's horrible.
Yeah, she
I
was 8
understand the
months
logic,
pregnant.
but what she must have went through, horrible.
Yeah, she was in and out the hospital. Like, we lived at the hospital during that last month of pregnancy for
Of
sure.
course. You got to be monitored, you never know.
And then she went sepsis after because of the
Oh,
kidney
boy.
stones because it caused an obstruction. And so 5 days after she gave birth, she ended up in the hospital dealing with that with a tube in her back because she
Wow.
wasn't her
Yeah.
kidneys weren't functioning.
Well, her body'd gone through so much. You kidding? And then when it's kidney
Yeah.
stone, the kidneys, right? It's obvious.
Yeah, is one of them was like 9 millimeters.
Been there. I think my
Yeah.
biggest was 13 millimeters, but they
Yeah,
have a
that's
variety of procedures they can do, thank God.
yes.
Yeah, which is nice. But over the many years, there have been so many different procedures.
I had one, I guess it was, I don't know if it was last year or the year before. And I was like, this is miserable. I didn't need to go through this.
No. You
I'm
really
like, I
don't
didn't need to
wish it on anybody.
I did not need to experience what my daughter experienced. I'm like, no, thank you. I
Well, people
experienced
get it
enough on
once
my
in a
own.
while, or gets it once in life. They swear like, oh my God, it was the worst. Well, I've been chronic.
It is worse. She says it was worse than childbirth.
See, and that blows my mind every time a woman tells me that because you're pushing out a 6 to 10 pound baby. You know what I mean? And I just can't get it through my head when they're this big, but they cause even more pain.
Well, it's because we dilate, so
Yeah, your body's
everything
made for
becomes
that.
bigger.
Yeah, right.
Yeah.
As a foreign object, your body wants to get rid of it, meaning the stone.
Yeah. It almost like shrinks actually because of the inflammation. It makes it even like smaller for kidney stones.
And your kidneys are full of meat. It's not an empty bowl. It's not empty. It's a big thing. So most of my stones are spiky. So I'll obviously bleed. So then you're bleeding, and I've had UTIs left and right since March, because what happens?
I'm going to see what was happening here. Love Trapped was happening then for sure. Jan had just filed.
Yeah, to get the stay on the foreclosure, right?
Yeah, Jan had filed that.
That was May 22nd.
Yeah.
She said it to Jennifer. She said,
Mhm.
yeah, that's 60 days from May 22nd. June, July.
And then
Interesting.
that was that we just got that. That was right after. Yep, that's when they filed their bankruptcy,
Yeah.
their Chapter 11. Yeah, because it seems like the weeks on this stuff, they always come down in all the cases in
Yeah.
the same time period. You would think that they would be like, okay, here's this on this week and here's this, but it's like, oh, here's Mike's, here's Laura's criminal case, here's the bankruptcy, and it's just all during one time period.
Yeah. And they're all through different judges, different courts, you know what I mean? Different
Mhm.
bankruptcy and all that.
Yes, it is weird how it all happens that way. Because I was thinking, I probably wasn't gonna have much Owens stuff to talk about.
Well, you have August,
Although,
is it August 5th or 6th is the next judge hearing?
yeah, but Laura's appeal thing is due
For the
on what, the
DVRO?
29th in the Maricini case.
I believe. I have to look.
Her appeal brief is the 29th, so in like 2 days or 1 day, really, because it's almost the 28th.
29th, Wednesday.
I don't think she's gonna get it in.
And how I interpreted the last request to postpone or extend or whatever, right? There was some verbiage in there saying this will be it. You won't get another one. Is that how you understood
Right.
it? Okay.
Right. And I think and I don't know that I've seen another reply that says, hey, can I have it extended to August?
Well, it's not the 11th hour yet.
That is true. It may be filed tomorrow. Or maybe it was filed today and it just isn't up on the docket yet.
That's true too, yeah.
But
I wish her well. If she really feels strongly about getting this for a lifetime, go for it. Personally, I'd be refocusing all my energy toward a bigger issue, don't you think?
yeah, my freedom. I mean, but you know what? If she goes to jail, at least she will have a roof over her head.
Yeah, basically with the bankruptcy information we've heard, right? Her parents will be a lot better off
Seasoning in it to make it yellow rice.
because the funds that they're spending would need to be spent.
Do you have a fork?
I'm gonna go down. Can you get a fork, baby? This is stuff.
I'm
okay?
picky, so don't take it as anything.
It's
You-
okay. This is my first time cooking it for him. Last time I cooked, I made it with his mom.
You want to say hi?
Where's this?
It smells good. It
Hey!
smells good. Thank you. We have smell-o-vision. Hi there.
Oh, you have headphones in, right? Or no?
Mhm.
Oh,
Yeah, my mic is hooked up.
I mean, it's understandable if you don't like it.
I'm picky about rice,
I know.
Oh, that's
that's fine.
but
Hey, how we made it?
if it's flavored rice, I may not have a problem with it. Is
Oh, good. You're
onion?
doing the taste
That's-
test. I love it.
Oh, it's got cabbage in it. I like
Mhm.
cabbage.
And all the healthy vegetables. Make sure it's all in it. I just took it out.
That's hot.
Put my heart and soul in here.
That's good.
You like it?
Mhm.
Well, there's gonna be some if you do want.
Okay. I'll make me a plate.
Do you have to be careful about herbs and spices for yourself?
No, I can't really handle a lot of spicy food.
Okay.
Ever since the vid, my tongue cannot handle spice, even sometimes ketchup because it's acidic-y. It
Yes.
tears up my tongue and I can't handle it.
Yeah, I'm more of a basil,
I hate.
oregano, rosemary, right? That kind of. herb spice.
Oh, I
whatever.
love that kind of
Yeah,
stuff.
I can sprinkle that parsley,
some-
sprinkle that on everything.
Garlic. I like
Yeah.
me some garlic, onion powder.
Yeah. Oh yeah, I love the powders.
Yeah, they made like, it said it was like jasmine rice, potatoes, ground beef, like peppers, cabbage, and onions.
Oh, okay.
It looks good and tastes good.
Yeah. Well, any kind of vegetable blend like that, you know, you're gonna carrots are always going to add a little sweetness to it, you know.
Yeah. All right. Let me make sure that we don't have. Well, that's in a different lawsuit. Make sure we don't have any more updates on this that I know of. I am going to go watch Lauren and Patrick and Omar and their legal takes. So that's where
good.
I'm going to next.
I'll do that next too.
So I don't know if they're still live or not though. Okay, let me see here. Are they still live? They are still live, so I'm going to move everybody over there.
Oh, good. Well, thank you everyone for spending your night with us, and I hope you have already hit your like button for Loud Little Ducky. And if anybody shares their streams, go right ahead and use that link and send it out to everybody you know. Also, if you know anybody who is in the mood to subscribe, I think Loud Little Ducky is worth subscribing to. She provides a lot of
Rob
tips and good information, and I think it's well worth your time and money. And it's not that expensive either. But subscribing is free, so it's only memberships that cost money. So I always want people to realize when you hear the word subscription, right? You think, I'm not buying that. No, it's not that kind of subscription. I so want YouTube to change that name.
Yeah. All right. So I am redirecting everybody over to Lauren's stream. Tell her Ducky and Rob said hello.
Bye, Colorado.
Insight. Good night, y'all.
Thanks, Ducky. Bye. Take care, y'all.